I think we're live, Erin.
All right. Well, hello, everybody. It is Tuesday, October 13th. It is day 2 of the Amy Coney Barrett nomination hearings. And we're here with all the literal tea. Just as a reminder, Amy Coney Barrett was nominated by President Trump to fill Ruth Bader Ginsburg's seat on the Supreme Court. Yesterday was just opening statements from the senators and Amy Coney Barrett herself. Today was kind of the questions from, it was questions from the senators and to Amy Coney Barrett. And then tomorrow, same thing. Thursday is outside witnesses, and I actually still don't know what that means. Just a reminder, you can drop questions in the chat. I should introduce myself. I'm Erin May Quaid. I'm the Advocacy Director of Gender Justice. It's been a whole day. And my guest, my panelist with me.
Your guest. I'm Jess Braverman. I'm the legal director at Gender Justice, and I think we're like every minute of C-SPAN, we're just like slowly losing our minds. So don't mind us. We are here today to talk about our sexual preferences.
Oh man, did that bother me? Yes, Amy Coney Barrett said today about LGBTQ people, based on their sexual preference, and I was like, girl.
I think she was just saying like she thinks the law treats like tops and bottoms equally, like no one gets preference.
Oh,
like just your sexual preference, like whatever.
You should treat tops and bottoms the same, equal protection
under the Constitution. Yeah, it's unclear where she got that language. She apologized after being called out on it, but it was odd.
It was offensive. Let's just be real. Let's just be clear. That is language that anti-LGBTQ hate groups use to discredit our existence. So let's just be clear.
It's kind of like it kind of has the same feel of like reading an opinion that talks about like the homosexual lifestyle. Like you're just like, oh, who's writing this?
Which the lifestyle, I have to say, is just like super normcore, I guess. I don't know. We like go to Home Depot. We have dogs. I got a Subaru, it's all on the lesbian agenda. But let's dig into like the juiciest stuff of the day. And this is just so in the zone for gender justice. There was a lot of conversation today about abortion, not yesterday, but they did talk about abortion a lot today. Roe v. Wade came up. Jess, what's the top line news about Roe v. Wade and Amy Coney Barrett?
The top line news. Oh, well, it's hard to talk about just this topic in a vacuum. So is it okay if we talk a little bit about like the super precedents?
Always.
Okay. So super precedent is this kind of word, I still think only academics use it, and it comes up in judicial hearings. Like what it is to me is a way for like people who are like conservative originalists to be like, here's a fake reason why I would never overturn this, but I would overturn this. So the two cases that often come up in these super precedent discussions are Brown v. Board of Ed and Roe v. Wade. Yes.
And Brown v. Board did what?
So Brown v. Board of Ed was, so back before Brown v. Board of Ed, there was Plessy v. Ferguson. And back even before that, the law decided that judges decided that Black people are not like citizens or people under the Constitution because
the Constitution said it.
Because the framers would have never like thought that Black people are people. But so that was Dred Scott. You get like Plessy v. Ferguson, which is after that, which is like, segregation's fine because it's separate, but like why not? Who cares? So then you get Brown v. Board of Ed, which basically says it's about segregated schools, and it says like separate but equal is never equal. And it basically was the case that mandated that schools cannot be racially segregated, which of course, the idea.
Wait, I'm going to pause you there.
Yes.
So that's the super precedent is, does this stand? Does the case that was decided before, are you going to uphold it? So Brown v. Board, that they always talk about super precedent there, and then Roe.
Yeah, and the reason I think Brown v. Board comes up a lot in these discussions is because it's an equal protection case. Like the idea of that case is like there's nothing, just like the word abortion isn't in the Constitution. I don't think the word like school, or at least in the context of like segregated schools, a lot of states have in their Constitution provisions about like funding for religious institutions or whatever, but like racially segregated schools, like those words aren't in the Constitution. So a lot of people who say Roe v. Wade is invalid will say like, oh, well, the word abortion isn't in the Constitution. Where's this right coming from? Where's this privacy right? I don't see it.
Yeah, that's the problem too, is that it's not in the Constitution. That there's no other problem people have with Roe.
Right. But like,
But
the same
yeah,
can be said about Brown v. Board of Ed. So originalists want to be like, no, I hate, it's like women and gays, but like black people, like obviously we know like there are gay black, Aaron, there are gay black people.
I've heard this.
There are
I
black
mean,
gay women. But so segregating people like that is a problem, but the courts do it, the law, the law does it. So like it's basically like, we're not racist, we don't believe in segregation. So Brown v. Board of Ed, how do we avoid like having that be a problem for originalists? We'll just call it a super precedent. Like no
I
one,
see.
I may not agree, I don't even have to talk about whether it makes sense in my judicial philosophy because I'd never overturn it. It's a super precedent. And I think like that's the only purpose the word super precedent serves, is to make originalists have a basis to say like that they wouldn't overturn Brown v. Board of Ed.
And I'm just a loving note for us to speak a little bit slower, because both you and I can be machine gun speakers, which we will talk about machine guns. So when the topic of Roe came up, and oftentimes it happens in confirmation hearings, people do ask the justices or future justices, will you overturn Roe? And there's usually kind of like lip service given. So for example, I think it was Kavanaugh or Gorsuch, both in their hearings said like, Roe is precedent. They paid lip service to it. And for one of them, their very first case after joining the court maybe it was Roberts, was to undo Roe. And so I think people have seen through it, but Amy Coney Barrett didn't even pay lip service to it and call it a super precedent. She was like, nah, it's not.
Yeah, so the whole thing is like, oh, there are some cases where we just accept it. So no one's really running around filing lawsuits challenging whether you can racially segregate schools, which is like, I think there's been like tons of litigation on like busing and all kinds of stuff, but like whatever, taking this as true, which I don't know why we would.
Emotion dismiss.
So the idea is because Roe v. Wade was Planned Parenthood v. Casey is another abortion case that came after Roe, and it really did change. Roe established that abortion is protected under the Constitution, but Planned Parenthood v. Casey, which came later, did somewhat change the way that the court is supposed to balance a state law that restricts abortion with the constitutional right to an abortion. So
with
Planned
undue
Parenthood,
burden, right?
what'd you say?
With undue burden.
Yeah, it was the undue burden standard case. So, what they're basically saying is like over the years, Roe keeps getting challenged, it keeps coming up, and because it's contentious, we're not going to call it a super precedent, which like, come on. So Roe v. Wade, it's because a judge can't say how they would rule on a hypothetical abortion case. Like they're always going to say, as you heard over and over again today, I can't rule on that. I can't decide on that.
I don't do hypotheticals. I need to have the case in front of me and the facts and talk to my colleagues and all that kind of stuff.
So then they change the topic to like precedents and super precedents, and you get basically the same answer. The problem is like you kind of have a sense of how people are likely to rule. Like if you say I'm an originalist in the vein of Scalia, it doesn't take like a great detective to figure out what that means. He's written many opinions.
No, Mr. Magoo could certainly figure it out. I think, it's important to note, and some of the senators did too, right? President Trump has been very clear that he said, and I'm almost going to be verbatim, Roe will go away automatically because I will nominate judges who will overturn it. And then Amy Coney Barrett has signed a letter saying abortion should be illegal. And so it feels a little bit like gaslighting to be in this committee hearing to say, okay, so the Republican Party platform says get rid of Obamacare, Obergefell, which gave us marriage equality, and Roe v. Wade. And then President Trump said Roe v. Wade's going to go away automatically. Amy Coney Barrett has signed a letter saying abortion should be illegal. But then we're supposed to pretend none of these things exist and the whole world has never happened before this hearing has happened. It's a little bit maddening.
Right.
But can I ask you to explain originalism and originalists, because that did come up a lot today.
So there's different, as she was saying, there's different like flavors of originalism. So there's an originalism where it's basically what were the meanings that could be attributed to like the phrases in the Constitution, like how would people have understood them back when they were written? But of course, they're thinking about like white moneyed men, right? It's not like how would like the general peasantry, like how would, right? They're not like, how did the gays feel? How did the Jewish people feel? You know, because I don't know that there weren't, like, it's really like, how did the people who wrote the Constitution, how would they have interpreted like the meaning then?
Yeah, and
Yeah.
I'll just give a quote. Amy Coney Barrett said about originalism that that means that I interpret the Constitution as a law. I understand it to have the meaning that it had at the time people ratified it. That meaning doesn't change over time, and it's not up to me to update it or infuse my policy views into it. So that's a really interesting position for a woman to take, I feel like, as a judge, because wouldn't like an originalist be like women shouldn't hold power?
Yeah, I mean, the right for women to vote wasn't originally in there, but you know, she called into question what it even means to have a constitutional right to vote. We can talk about that,
Right.
but so there is like the equal protection provision, the 14th Amendment. Everyone has equal protection of the law, and I know Justice Ginsburg really pushed for that to prohibit sex discrimination. But that, you know, most originalists, Scalia certainly didn't believe that that was correct. So Ginsburg was successful in that push. It's the reason we have a number of interesting opinions, like we talked about this in a previous SCOTUS chat, but like the Virginia Military Institute opinion, where there was a prestigious military school. It's run by the government, so the Constitution applies to the government. So if someone's violating your constitutional rights, the person you're suing is most likely the government. Occasionally, we don't even need to go into it. Like occasionally it can be a private party, not important here. It's mainly for the government. And so the Virginia Military Institute was not allowing women cadets, but it was this prestigious school that gives you access to a lot of opportunities and positions of power. And so she basically found that that was unlawful sex discrimination. Scalia definitely did not agree with that. So I think it'd be an interesting question for Amy Coney Barrett, like, what would the framers think about a woman getting to interpret the Constitution in the first place as a judge?
Right. It is. It would have been interesting for someone to have asked that.
And the words like women judge aren't in the Constitution, so maybe she doesn't have that right. I don't know.
Well, you know, a lot of our constitutional stuff says he shall and he will appoint and he will nominate, right? And so, I mean, we know this is why, like, adhering to the literal meaning of the people who wrote the Constitution is bad. Like, they did not view anybody outside of wealthy white men to be people who have power. And so it was, I think he was a chief justice, but John Marshall, who wrote, you know, a document for the ages to like grow and change with like time. And so to not look at the value point and then apply it to the time just seems like a really weird way to justify upholding white supremacy. So there was a lot of talk about, we have voting rights, Cantor, which is like gun rights. So can you talk a little bit about this virtuous citizens? Does that make sense to talk about that first?
Yeah, that's another one of those areas where, like, I think judges get to like pretend they're making non-policy decisions when they are. And there's all these like tortured, like, it's kind of like super precedent, like all these tortured ways that judges can be like, no, like this makes sense under this originalist framework because dot dot dot. So the idea is like, she decided this case on the Seventh Circuit about gun rights for people with felony convictions. And I don't actually, this is not popular. I'm not a gun rights person. Like, I do think that people with felony convictions are treated as though they're, you know, everyone's like a violent and unrehabilitative person. It's a felony in Minnesota to like keep a rental car for too long. It's a felony in Minnesota to like, if you steal a bike worth under $1,000, it could be a misdemeanor or gross misdemeanor. And if it's over $1,000, it's a felony. So I think she's right. Like, there's no reason to equate like violence with having a felony on your record. Yeah. I think it's ridiculous. But she ruled basically, or she was, I think, in a dissent in a case about whether the government can prohibit people with felony convictions from owning firearms, I believe was the issue. I didn't read the full case in detail. It's been a long day with a lot going on. And she dissented, basically saying, like, for what I said, you know, if the government does get to curtail someone's Second Amendment rights to bear arms, they have to actually prove that the person is violent, because having a gun is an individual right, and the government has to actually show that the person doesn't have that constitutional right. She parsed it like there was way more parsing than I'm giving it right now, because when they want to find the results they want, the decisions suddenly get like super complicated, and it's not just what did the framers say about this all of a sudden. Voting rights, she says, are like civic rights. So like the right to bear arms, and I don't think everyone feels this way. I don't even recall learning it this way when I was in law school, but like the right to bear arms is like an individual right. Each person has it, but the right to vote is like a civic right. So like people can have it if they're a virtuous citizen, is what she said. So felons are suddenly not virtuous citizens when it comes to voting. She brought up voting for no reason in a dissent on a case about gun rights, and kind of for no reason opined that it's totally fine to take away voting rights of people with felony convictions.
Well, then look no further than the 3 Trump judges in Texas that ruled that it's fine for the governor of Texas to have one ballot drop box per county, because it was equal that, every county got one. It doesn't matter that some counties have like 100 people and some of them have like 4.7 million people. It's all equal. And I think that was a wink and a nod to some of the voting issues that are before the court now and will likely be before the court in the future. But it was a little bit off-putting to hear that only, in her view, virtuous citizens should be able to have the right to vote, as if like a civic right and an individual, like rights are rights. And so they just are what they are.
I mean, I think another interesting issue is the Voting Rights Act, which came up. So there was a case, Shelby County v. Holder, where, the Voting Rights Act was put in place because despite the fact that in the Constitution, people have the right to vote, including Black people, in the South, there was massive voter suppression targeting Black voters. So the Voting Rights Act was supposed to push back, and it targeted some of the places where voting suppression is the worst. And in Shelby County v. Holder, which was a Supreme Court case where Ginsburg dissented, they struck down a provision of the Voting Rights Act that was intended to push back on voter suppression. And now, of course, we know, so Amy Coney Barrett is a textualist, so she reads the language of the text as would have been either its plain meaning or as would have been thought by the people who enacted it, or whatever it may be. But if you have voter suppression, then the voters aren't even getting to vote for the elected officials. It's people who, white people with money who live in smaller towns with more access to voting, where you're not waiting in like a 12-hour line, which we're seeing in parts of, Georgia
and Texas. Yeah,
and Texas.
Georgia, yeah.
So the Voting Rights Act, it's still as a whole up there, but provisions of it have been struck down by the court.
Really,
and
the enforcement pieces, the pre-clearance. Right?
Yes.
If you're going to change a law about people voting, you have to clear it with the federal government to make sure that it is not discriminatory. When they got rid of that, lo and behold, all of these poll taxes in Florida, one ballot box in Texas, people waited for 12 hours to vote yesterday. If that's not voter suppression.
Right. And courts are absolutely making policy calls like all the time. The idea that courts aren't making policy calls is just so disingenuous.
It really is.
Yeah.
So I'm gonna switch us a little bit to, I'm gonna make sure there's no questions in the chat. If people have questions, feel free to ask. One of the things I was really struck by today is the depth of questioning from some of the senators. And I want to specifically talk about Amy Klobuchar. At the beginning, she was telling a story. She was like, I was on the walk with my mom and there were some tracks of a moose or a bear or something. And I was like, where is she going with this? And she was like, and so in the absence of Amy Coney Barrett's responses, I have to follow the tracks. And as soon as she said that, I was like, oh, I am so with you, Senator next door. She did a really good job of kind of saying if we're going to follow your track of, things you have done, things you have said, things that the people who supported you and nominated you have said, here's the logical conclusion. I just really enjoyed everything that she did. And it was one of the few times that Amy Coney Barrett was giving more away with her face than I think she did. She's a remarkably unflappable woman, I was going to say. She's very still, she doesn't fidget, she doesn't blink very fast, but there were a few times where, because she was so kind of stoic for a lot of the hearing, that when she was irritated, it really came through, because it was a marked difference from what she'd been doing before, and that was one of those times. where was I in my little outline? You pick up the next point because I think I must have lost it. It's fine. It's a free one day.
After that, I have listed sexual preference, which we already covered.
The ADF.
The ADF. You know, just to talk for a second about another thing that kept coming up was like the Scalia-Ginsburg friendship. There's a lot of talk about like how great it is that people on opposite of the sides of the aisle can be friends. I don't really understand that. You know, like when I was a public defender, I tried really hard to get along with prosecutors because you have to work with them, like you have to negotiate with them. You might, you know, you have to work out settlements with them sometimes when your client wants to settle the case and you want that to be as favorable as possible. There wasn't really a reason to go after them. But I don't know that I would have been a better, like, I don't know that you can judge me as a human being. Like, am I going to the Mall of America with my best friend, the prosecutor? Like, I don't know why, like, that's an expectation or that's considered something positive or virtuous. You know, I'm in a courtroom. I feel like they're doing something that's really dehumanizing and upsetting to my client and to me. Like, why I should have to be friends with that person as opposed to like we get along civilly. I don't know why that matters. So people, you know, brought up the friendship a lot, but
I think the point with that, it's because for a while, you know, who did Gorsuch replace? Because it was when when Gorsuch, it was Merrick Garland, but then it was Gorsuch. Whoever left the court.
Was it Kennedy?
It might have been. I think it was a conservative justice or more conservative justice. And they talked a lot about having a lateral move. That the person, that's why they didn't confirm Merrick Garland or give him a hearing.
It might have been Scalia, actually.
It might have been Scalia. Yeah. And I think that because there was such this hoopla around a lateral move, you have to replace a conservative justice with a conservative justice. And also Amy Coney Barrett was a law clerk for Scalia and is replacing Ruth Bader Ginsburg. I think they were trying to like lessen that, like, oh, don't worry that Amy Coney Barrett's replacing Ruth Bader Ginsburg. She was friends with Scalia. I kind of think that was the piece. I do want to flag for folks, and we'll put it in the comments, Senator Sheldon Whitehouse had this 30 minutes of must-see C-SPAN. And we'll drop it in the comments. It was, you know, things I know. It was things I don't know. It goes back to this piece of, are we to pretend that this nominee came out of, you know, just like some random, you know, judicial branch of some random place in Notre Dame, you know. The Federalist Society exists. It has been funneling money into creating the kind of judiciary they want in order to, again, repeal and overturn Roe and Obergefell and create a society where it doesn't matter if corporations discriminate against people, everything for their bottom dollar. Wealthy money interests have been invested in exactly this moment for a very long time. And Sheldon Whitehouse used his 30 minutes incredibly, incredibly well. So we're going to drop it in the comments and encourage everyone to watch it. I thought it was highly illuminating and a really, really good example of how questioning or presenting can be done really well.
Yeah, he didn't ask any questions, but we did get a question. What was your take on Senator Whitehouse? I think what he brought up is actually really important. It's kind of how groups are really taking over the courts with just like tons of financial backing. So you have groups who are like handpicking judges. They're paying, like, they're the same, you know, what he was saying, and I haven't followed the money myself, so I'm basing it on what he was saying, is that there are organizations that are bringing, like, picking the judges, bringing the litigation, like with the same money, the same groups, like, and in that same litigation are paying for numerous groups to write amicus briefs in support of their position in the litigation. So an amicus brief is basically a friend of the court brief. Like if someone else is litigating a case and I feel really strongly, like Gender Justice feels really strongly about an issue in that case, we might write a brief supporting their position from an interesting angle that we think the court should consider. I'm not allowed, like if people write amicus briefs for us, I'm not allowed to like edit them, right? Like the idea is like the person bringing the lawsuit should not be the person also writing an amicus brief in support of their own lawsuit. But it's like what he's saying is like the money, the way the money is just like millions of dollars are going into like picking the judges, bringing the litigation, pushing them through to the higher courts so that you get like a binding opinion that's kind of a bigger opinion than you would get at the lower level. And they're funding the amicus briefs. And it's a huge problem. And, you know, it's the same groups that are pushing the idea that like the only valid way to read the Constitution is through a certain originalist lens, which is absolutely not true. It's just this idea that gets pushed now. And this idea like judges aren't policymakers, which is really like, I don't know how you read any court opinion from either side and come to the conclusion that there's no, like, judges are machines, or like they're not in at all inserting any policy considerations into their opinions. It's just really, it's like, it feels insulting.
It does feel insulting. And I think this actually goes to, like, Becca, your wife had some questions
Yes.
for us. And do you want to grab them?
Yeah. I
Because
have them on my
there you
phone.
go. There you go.
So we got a question from a listener.
A dear listener.
When asked if they'll overturn Roe v. Wade, marriage equality, etc., many justices claim that they will respect it because it's already been decided and is the law of the land. As a way to avoid answering the question, once they're on the court, what do they actually have the power to do in terms of overturning it, and how will it play out? How can they claim it's decided and done if they have the power to undecide it?
I think this is one of those really interesting, it's part of why these hearings are so infuriating, is because for the folks who are deeply interested in somebody with Amy Coney Barrett's, belief system and her feelings about who gets to be pregnant and remain pregnant, and about gay folks, and blah 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 blah, all that, it aligns with theirs. And the reason that they're so interested in this going forward is because once it's done, she's on the court forever. And that's the point, right? They just have to get through these hearings and get her onto the court. And then it kind of, Congress can impeach a Supreme Court justice. It hasn't happened in a very long time. And Brett Kavanaugh was credibly accused of sexual assault after he was seated on the court, and he still hasn't been impeached. So, like, I think that really is the, how does it play out? We lose rights and they roll them back, and all we can do is protest in front of the court, or wait for somebody else to retire or die and replace them on someone else. And so the reality is like, it doesn't really matter what they say in these hearings about what they will or won't do. It doesn't matter. No one's sitting over there being like, well, first you said that you weren't going to overturn Roe when you did. We can write all the articles we want to. They'll have this job forever.
Yeah, they can't be elected out. They can't be overturned, like they are the Supreme Court. For people who think that, like, the judges wouldn't overturn Roe v. Wade or Obergefell, I will tell you that there have already been dissents or opinions or statements written by judges in cases that get published saying Roe v. Wade was wrongly decided. Obergefell was wrongly decided. And that's basically them saying that they are willing. Like, why would you write a dissent saying these cases are wrong if you're not actually willing to overturn them if you get a majority? So there are judges who, like, every time, so the way that these cases get overturned, to Becca's question, is like, so Roe v. Wade, there have absolutely been dissenting opinions, including by Scalia, I think, was it Gonzalez v. No, there have been dissenting opinions by Thomas, by Scalia, by Alito, saying that Roe v. Wade was wrongly decided, abortion's not in the Constitution, there's no right to privacy, right? So those dissents have absolutely been written. We recently saw an opinion from Alito and Thomas regarding Kim Davis's case. She was the clerk who refused to sign gay marriage licenses. The issue the court got, which they refused to hear, wasn't about Obergefell squarely, but they still just wrote an opinion saying Obergefell was wrongly decided. So I do think that if they had the majority, they would actually overturn it. I don't think people are being ridiculous when they claim it. I think we should take them at their word, right? Like they say they would. The other thing to consider, yes.
Can I add the other piece too, is that one of the ways that this was introduced today was like, well, how does something reach the court? A state passes a new law, then somebody sues over it, then it goes to trial court, appeals court, then to the Supreme Court. The Supreme Court has to agree to hear it, and then they hear the case, and then they decide. That is not the entire story. A state wouldn't have to pass a law overturning marriage equality in order for them to overturn or chip away at that right. And I think it's the chipping away at that folks miss so often, that sure, they don't have to overturn Obergefell, but now you really can only get married in places where people will sign your marriage certificates.
Right,
or you'll only get married in places where people will allow you in that city or that county or that jurisdiction to actually recognize your marriage, and on and on and on. So you chip away at it through saying, well, you don't have to give foster kids to LGBTQ families. You don't have to serve them a cake. Now you don't have to sell them a house. Now they don't have to live in your city, blah, 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 blah.
That's exactly right. So you chip away at it, and then the courts let you chip away at it. And then they say, well, it's not a super precedent because it's been chipped away at, like in the passive voice. So
not our fault. We just heard
what
the
are you
case.
gonna do?
I don't know who keeps chipping away at it.
There was, unless there's more to say on Becca's question, we just want to talk a little bit about the Affordable Care Act again, because like, why does that keep coming up? In this coming term, the Supreme Court will decide whether the Affordable Care Act is constitutional. There is a provision in the Affordable Care Act. Basically, Roberts had, people put Roberts on the bench thinking that he would throw out the Affordable Care Act. He did not. So the Republicans, I think what they did was they got rid of the provision that kind of saved it, which is the idea that it's a tax. Like Congress, when they pass laws, they have to do it within their power to pass a law. And one thing they can do is like tax. They have a tax power. So the Affordable Care Act had that. You remember you used to get those sheets that are like, did you have health insurance every month? And you'd have to check it off, or there was a penalty. Now you still get that sheet, but there's no penalty because the penalty is zero. So with a zero penalty, the question is it still a tax? Like, what is it, a tax or a penalty, first of all? And like, if it's zero, is it a tax? So basically the question is it a tax? And if not, can you, like, if you sever that piece off from the ACA, is it still constitutional? And if you're confused by that, don't worry. It might not be all that important to know the nitty gritty of it.
That was a great description, Jess. I think it's the best one in all of our SCOTUS chats.
So my God. Let's just turn it off now before we go downhill. But the idea is like, if is it severable? So that's why they're talking about that. Really, like, I mean, I think it's pretty clear that I think it's kind of likely that the Affordable Care Act could get struck down. I don't like to say things like that because I don't like to panic people. I don't know.
Well, 20 million people would lose their health insurance pretty quickly, and it would upend our healthcare system. I think it's important to be realistic. And I just want to insert one thing, that right after the Affordable Care Act survived its last Supreme Court challenge, it rested specifically on this tax thing. And right after it was decided, Vice President Mike Pence tweeted out, we need different conservatives on the court who will overturn the ACA. So again, like, no one's been quiet about the plan. This is just the plan that is rolling out in front of us.
And I want to add, the ACA, the Affordable Care Act, Obamacare, it's the same thing. The Affordable Care Act is also a civil rights law, so it prohibits discrimination in all kinds of healthcare settings. Super important. So Gender Justice argued and won. Christy Hall, our senior staff attorney, won on this question of like, the Affordable Care Act prohibits sex discrimination in all kinds of healthcare settings. Does that protect transgender people? And the court said, yes, it does. So in our jurisdiction, that, wherever that court ruling applies, basically insurance companies, I'm simplifying it, but thanks to that, you can't really just have blanket bans on gender affirming care, which is great. So the Affordable Care Act does that. It also mandates that as part of employee health plans, there has to be access to birth control. The court, not even the court, it was like the Trump administration, and with the court's blessing, basically said, like, anyone who claims you're a religious employer, not only like do you not have to provide the birth, like, it's not even you providing it, right? Like, not only do you not have to provide a health insurance policy that includes the birth control, but it's more than that. It's like, you don't even, then there was the option where, like, if you're a religious organization, you can sign a form saying, I'm religious, I don't want to do this. And the employees who need birth control can get like the separate money to go buy birth control, and you're not even providing it. And the religious organization said that's not good enough. So basically now it's like anyone who's a religious organization just doesn't need to provide birth control.
They're like, not only will I not give my employees contraception, but nobody else can. Like, we won't even do that. Like, that's what it is.
Right. And so,
So if the Affordable Care Act goes away, the Affordable Care Act, because of this, Section 1557, is the most recent expansion of civil rights law. And so if the Affordable Care Act goes away, so does Section 1557. It's very concerning.
So we got a question, like, what happens to the 1557 rulings if the Affordable Care Act goes down? Well, then 1557 doesn't exist anymore because it is part of what will go down. That does not mean, though, if you are watching this and you're worried about your gender affirming care, a lot happens in terms of healthcare. You'll see headlines that are like, Trump rolls back transgender healthcare. Ignore those headlines. it's not the case that all of a sudden like someone's going to come in and like grab your healthcare away from you, though it often feels that way and looks that way. And if you're being denied gender affirming care, make sure to check in on that, call someone, see what your rights are, because it doesn't necessarily mean just because an insurance company doesn't want to provide it doesn't mean they're allowed to do that. So don't be scared away by headlines. Don't be scared away by the Affordable Care Act. If that gets struck down, what happens to my gender affirming care? You can call us, Just Us Health. There's lots of organizations that can kind of either guide you or provide referrals or something along those lines. So I just want to say that.
I'm glad you said that. The last thing, and I'll end us out because we tried to keep it to like 30 minutes and we're like, yeah, close-ish, is that, you know, it is, so for a lot of people in the country, they already live in a world where abortion access doesn't exist. Okay, so a lot of states have one clinic, there's all these hoops you have to jump through. It's essentially inaccessible. Minnesota has also been victim to this chipping away at the rights. We have a constitutional right to have an abortion and decide to have an abortion, and those are different because making your decision and actually executing the decision are two different things. We have had that constitutionally protected from our Minnesota state constitution since 1995. And despite that, there have been chips away at that right, to the point where we have like 5 providers of abortion care in Minnesota left. There are about a handful of clinics where you can access abortion care at. There's a slew of hoops you have to jump through, a waiting period, a state mandated lecture. So if you are freaking out about reproductive rights, and you should, but you should have been already, like what's happening right now with Amy Coney Barrett, that's not the new threat. This has been the threat for a long time. Unrestrict Minnesota, which Gender Justice in partnership with Our Justice, NARAL, and a whole host of other organizations are leading the way to protect and expand our reproductive rights here in Minnesota. We have sued the state to say all of these abortion restrictions are unconstitutional from the precedent you set before. And so we are doing that work. We've been doing that work for a year and a half. Unrestrictmn.org. Go there, learn about what our laws are, donate money, because this is, you know, fund our work, because we really, if you've never seen more than ever now, I guess, that our rights are under attack, they are. And we are doing that work in Minnesota to protect and expand them. And so if you're freaking out, that's okay. Unrestrict is here. But that is something that you can do, and we'll drop that link in the comments.
If you're wondering what's going to happen if I watch my rights erode at the federal level, just remember gender justice is here. And we're working to protect your rights, at least at the state level, which is why, in addition to the unrestrict, we're currently engaged in that lawsuit to strike down a lot of the abortion restrictions on the books. And so Gender Justice is litigating that with our friends, the Lawyering Project. So yeah, if you're feeling down, just remember we're here.
We are here. Give us money, and we are working with, and we're working with folks in other states too to help like scale what we've done in Minnesota to other states too. So it doesn't just stay here. The work can go other places. So Jess and I are going to be doing our SCOTUS chats every night through Thursday. So join us tomorrow when we'll have Christy Wesson, who is with NCJW, the National Coalition of Jewish Women, Minnesota, and also they would do the Courts Matter work, which obviously courts matter, and she will join us. She's a delightful, like bright, shiny light of a person. Thank you so much for joining us. I think I might have to bring wine tomorrow, Jess. I just don't know if I can. Yeah, no more tea. I'm gonna bring the wine.
No judgment.
Thank you. I appreciate that. Everyone have a good night.